Welcome, everybody. We're just waiting for attendees to join us, but for those that are already here and on time, thank you very much. Good morning, good afternoon, well, shouldn't be good afternoon, but it might be for some of you, and good evening for those that are in Latin America and in Brazil. Delighted to have you here. We'll just give it a few minutes. It's quite interesting because both Adriana and Ben, who are in Sao Paulo and Hong Kong respectively, look as though it's the middle of the night, but for Ben, certainly it is early morning. We're just having a bit of a rainstorm come through.
But does it generally last long? Or just a few
really.
minutes?
Yeah, it can do, but usually they blow over, but it's just, it does look like the middle of the night. Well, I think we can get going. I know that people will join throughout, and certainly a lot of folks will be interested to view this afterwards, as is often the case when we're straddling Asia and Latin America. Time zones become a challenge. So we are really grateful to our guest today, Adriana Braghetta. She's based in Sao Paulo, Brazil, and she's the founder of Adriana Braghetta Advogados. She has many, many more roles and responsibilities and titles than this important one, and we'll hear about those later. But firstly, a warm welcome to everybody to the third series of the HK45 Virtual Fireside Chat series. I'm Kiran Sangera, a special counsel at the HKIC. And I was formerly involved with the HK45 committee, and this is one project that I can't let go of. So I'm really grateful that HK45 have let me continue on with this together with Mariel Dempsey and Duncan Watson. Ben Burry's here. You can see him there. He's the current HK45 co-chair and a partner at HFW here in Hong Kong, and he will be asking the questions today. Before we get into that, just a brief introduction to the series or the concept behind the HK45 Virtual Fireside Chats for those that are new to it. The first two series focused on showcasing specifically female talent in arbitration from across the globe. And all 11 guests represented different journeys, experiences, successes, different jurisdictions. We traveled through Europe, the Americas, and Asia. And we heard about the different motivations of our guests, their struggles. They gave us advice and also defined what success looked like for them. Very rich conversations that we had, and we continue those. But this series will also be showcasing those who support diversification of the profession more broadly. So we'll continue to showcase female talent, but we'll introduce others who also represent and support diversity in the broadest sense. But anyway, back to today. Adriana is a leading global figure in Brazilian arbitration, and her career is really intertwined with the development of arbitration in Brazil. The two actually go hand in hand. Perhaps it should be called the Braghetta arbitration law rather than the Brazilian.
No, not true. It's a large community. Don't say that, please. the thousands that we have here, other lawyers will say, no, it's not fair.
Well, that's me saying it. It's not you.
Okay.
But certainly a leading figure. And I've known Adriana for a few years now, so really, really pleased to have you here. She has many years to go in her career, but has already done so much. And given what she's done and her role in arbitration, her geographical location and her energy and passion for for this field. She's a perfect guest for us and a real reflection of diverse leadership in international arbitration. Thank you for taking the time with us today and for sharing what will be a fascinating journey. When we were having a chat actually together before today, Adriana did say it's been a hell of a journey. So we certainly look forward to hearing about this journey. And with that, I will hand over to Ben. But thank you very much, Adriana. It's really been a great reason to be back in touch. And I very much look forward to hearing from you. Over to you, Ben.
Thank you, Kieran. It's an honor. Thank you very much for the invitation.
Well, thanks, Kieran, for the introduction, and it's obviously a pleasure to meet you, Adriana, and everybody's. I know everyone who's joined will be sharing that view. So, of course, we just heard from Kieran that you're one of the leading arbitrators in Latin America and one of the most well-known lawyers, of course, in your home jurisdiction of Brazil. But particularly importantly, of course, is that your more than 25-year career has progressed in parallel with the progression of arbitration generally in Brazil. And part of the purpose of this talk is to intertwine those things and learn more about Brazil as well as about you. Shortly after you started your career in 1996, the Brazilian Parliament enacted the first piece of legislation in support of arbitration, the arbitration law. And 5 years later, in 2001, the Brazilian Supreme Court handed down its first decision in favor of the constitutionality of the law. In 2002, Brazil ratified the New York Convention. And at every stage, you've played an important role in the development of arbitration in Brazil. In 2001, a group of Brazilians, including yourself, created the Brazilian Arbitration Committee, CBAR, and you were subsequently appointed chair. In 2012, you were appointed to the ICCA governing board and subsequently as vice chair of that board. And back in Brazil, you've sat on a special committee to review Brazil's 1996 Arbitration Act. And in January last year, after more than 25 years of experience working on disputes, you founded your own boutique firm, Adriana Braghetta Advocados. And of course, you lecture at CEU Law School in Sao Paulo. So we're just going to start right from the beginning, Adriana, and roll through. For those of you attending, this will probably take something in the region of 45 minutes. You should feel free, participants, to put in the Q&A box that you'll see in the bottom of your screen, any questions that you may have. So let's start at the very early stage, Adriana. So tell us about your background, your education. Who were your influences growing up?
So thank you very much. By starting with also thank you, Ben, for this, also the kind invitation and the preparation of the questions and the preparation chats that we had. So my inspirations, especially in law school, I will name one because he after that he turned out to be my tutor in my PhD, and after that I joined his firm Elo Batista for 12 years. So I've been he has been present in my life for decades, and he passed away roughly a year ago. It's Luiz Olavo Batista. Luiz Olavo Batista was a professor of private international law at the University of São Paulo, where I studied law. And Luiz Olavo Batista was, in a later stage, he was the chair of the appellate body of the WTO. So whenever in Latin America, especially in Brazil, you think about arbitration or issues related to World Trade Organization, his name will come to everybody's mind. So he was a mentor and an inspiration throughout my life, and he was my partner after many years. So it was a great part of the joy of my professional life I owe to him. He was a very special human person as well.
Oh, that's a great story. Thank you. And you mentioned, of course, there your studies, and I can tell that your love of learning has played a key part in your life. For those of you that may not be familiar with Adriana's extensive CV, after graduating from the University of Sao Paulo in the 1990s, she studied a master's degree, two master's degrees, first in the University of Sao Paulo from 1994 to 98, and then at an organization I won't try and pronounce, but the abbreviation is FGV, from 2000 to 2001. And from 2000 to 2008, Adriana returned to the University of Sao Paulo to complete her doctorate, a PhD, and continues to lecture at the CEU Law School in Sao Paulo. So what do you think it is that keeps drawing you back to academia?
I think it's the passion to learn, definitely. That's also what motivates me to participate in seminars or the challenge of a panel that will be discussing something new. And we have something that may be quite unique to the region, is that it is possible, in fact, to work together with your postgraduate studies. So
Right.
After becoming a lawyer, to deepen my studies, I decided to do that. Obviously, if you go to an international firm in which you have to bill 200 hours per month, it will be difficult. But I decided to grow through my career, to follow my career in a way that it would be possible for me also to have my master degree by that time. It was a 5-year term to have the master degree. Nowadays, it's, I think, a 3-year term. And the PhD itself would be another 5 years, because in both you have to prepare a thesis. What happened then is that when I was at law school, still, we didn't have arbitration in Brazil. But I remember quite precisely when I was watching one of my professors, and his name is, he was one of Luis Olavo Batista's greatest friends, Professor José Carlos Guimarães. He taught about international arbitration. So I was, 19 years old, 20 years old. And when I saw this man talking about international arbitration, I decided right that moment, this is the thing that I'm going to study about. After I finished law school, I started my master's degree precisely on international private law, and I have prepared my thesis already in arbitration, not knowing if I would ever work with arbitration, because by that time we didn't know that the arbitration law would be enacted. So quite frankly, I was quite lucky as well, because when the law was enacted in 96, I was one of among 5 young lawyers who had a certain level of knowledge of what was going on. We had this older generation who would be teaching private international law, and arbitration was taught within private international law. And then we have this group of we were around 28 years old, 30 years old, and the arbitration law was enacted. So I was very lucky at the end. And by that time, nobody knew. I'm talking about 1996. The Arbitration Act now this year celebrates 25 years. In 96, the first case in which an arbitration award was being requested to be enforced in Brazil, the Supreme Court of Brazil decided to discuss its constitutionality. So we had a good law based on non-citral model law, but all of a sudden we had this tension. And this tension took us a lot, took us 4 years until 2001. So by this time, nothing really happened. Everybody was waiting a little bit for the decision on the Supreme Court. When the Supreme Court decided, oh, the arbitration is constitutional, it had an immediate impact on all the different levels of court tribunals and lower courts. So, because it was a decision from the Supreme Court. So immediately the effect was, after that, 2001, we ratified New York Convention, and from a legal standpoint of view, everything was ready to start with arbitration. And then we created, the idea was from one of my friends, João Boscoli. He had done his PhD in arbitration in France. One of his mentors was Professor Philippe Fouchard. I'm not sure if you have heard about Philippe Fouchard, one of the top names. So Philippe Fouchard had a few Brazilian students, and João was one of them. We met because we are few people who were passionate about arbitration, and said, Adriana, I have an idea. Why don't we do in Brazil what the French people have done here, which is the Comité Français de l'Arbitrage.
Yeah.
So we said, well, it's a great idea. And we started like 20 people in 2001. Again, without knowing what would come, without knowing what role we will take in the future years.
And you must have met did you meet some skepticism within your... Obviously. What was being said at the time? What can you remember about people who doubted whether arbitration would become what we know it is now?
Yeah, but people, I think, in those early ages would say, but people will go back to the courts. People will try to set aside. Oh, it's not going to work. First, even in South American countries, I remember going to Argentina. By this time, I was working at Baker McKenzie. I remember meeting some lawyers in Argentina who would say, no, we don't like arbitration that much. They were facing the exit problems also. Said, we don't like it. It was possible to perceive that the culture in other jurisdictions was not favorable towards arbitration. But in Brazil, what we did was the following. We created an association, very, I think, bearing in mind that we had a white piece of paper that we had to fill in. We had no experience and a brand new law, and we had no culture. So we had to develop all that. And the first step would be, and we did it for many years, we followed Philippe Fouchard's advice, was to engage since the early stage with open dialogue with judges. I think this was step number one. The skepticism came also from the one who would say, a judicial judge will never let go the power over a case, the control over a case. And by the end, after a few years, we could see it in Brazil, especially because we had this decision from the Supreme Court that the Brazilian judiciary was very in favor of arbitration, especially it was completely aware of the fact that arbitration was an important tool to attract investments. I think in this open dialogue that we started to have, they could understand, you have part autonomy, it's a different methods, you have important stakeholders, we were talking about experienced people that are doing international business. So rule of law, it's important, you know. If you have chosen arbitration, go for it. So we have had, obviously, as you mentioned, we have had lots of difficulties. But I think the judiciary came along, we started to create a community, the international agreements started to, all of a sudden, to choose arbitration. And if I may add to that, what we have seen in a certain moment, after, obviously, after a few years of disseminating the word of arbitration, inviting foreigners to come, we could see, and this is, I think it's a unique scenario for Brazil. We had seen a growth in domestic arbitration because of the amount of work that judges have in their day-by-day activities. A lower court judge can be handling more than 4,000 cases, just to give an example for you, which is astonishing. Obviously, it's a totally different structure than you have, than the one that you have in UK, for instance, in comparison with UK or Hong Kong. But in complex cases, even domestic ones, people start saying, you know, as it's too burdensome to go to the courts, it will take many years. People have the opportunity to appeal once or appeal twice, to file interlocutory appeals. So let's go for arbitration. So we've noticed this immense growth of number of cases after, I don't know, I would say beginning 2005, 2006. We have noticed a large growth in the number of cases, and with that, everything grows. The community, the international interest towards Brazil. We have seen international firms trying to go to Brazil. We have seen lots of foreigners trying to go to Brazil to be appointed as arbitrators, and it was a success.
So there's sort of two factors there, aren't there? Then there's the sort of gradual promotion, I suppose, of arbitration as a genuinely viable alternative to the court, and then there's the actual infrastructure problems that are in place in Brazil with, and in so many countries in the world, with burdens on judges, which just slows the process down. Now, when you created the committee, the Brazilian Arbitration Committee in 2001, you must have identified some of those issues even at that early stage. So can you recall what your objectives were, and to what extent do you think now, looking back 20 years later, those objectives have been achieved?
Oh, I think we couldn't have imagined the success that we have achieved. It's success, but much greater than we have anticipated. In the beginning, obviously, we would have hoped for arbitration to be used as a viable method, especially international contracts, but we couldn't have imagined the growth and actually the potential of the economy. Another important fact, Ben, it's the size of the Brazilian economy. It's huge. It attracts lots of investments. And although it may be a domestic case because it's a subsidiary of international company dealing with another Brazilian, as the money came from abroad, the international culture also comes, and also the willingness to use arbitration, even in domestic cases. So we couldn't have anticipated. Obviously, in the beginning, we faced challenges I think one challenge that was quite clear for us was the issue of the competence. It was quite tricky in the early stages. Should the judge wait for the decision of the arbitral tribunal? Why is that? The judge themselves would ask us, well, why is that? If you don't have a valid arbitration clause, why we have to wait? And we would say, because it's the system. You will have your say. I remember in one case, one of the, I think the year was 2004 or 5. I think also it was my first appointment as arbitrator. We received the case, and all of a sudden we saw that one of the parties, this party was not participating, filed the lawsuit in the courts of Rio de Janeiro. And we received a decision from a judge saying to us, ordering for us to suspend the proceedings. And the three of us, members of the tribunal, said, it's for the first time that it was a female judge. She's assessing the issue of arbitration, totally understandable. What should we do? Should we suspend the proceedings or go forward? So we decided to do the following. We prepared an answer to this judge, explaining the principle of competence, explaining to her that the judiciary courts will have a say, will have a formal control at the end, that everything is prepared similar to the, or in the same ways as the UNCITRAL model law, but an interference in an early stage would jeopardize the proceedings and would jeopardize party autonomy. And a few days afterwards, we have received a decision from her. She had terminated the court proceedings, saying, I understood competence principle, and you cannot pursue the anti-suit in face of the judiciary prior the award is issued. So it's a lot of work. It's one step after the other. Large community. We had to face those type of things various times. But I think the general perception is, and the general application by the judiciary is very good. Mm.
But it wasn't just the judges you were persuading. You also sat on the special committee for the review of the 1996 Arbitration Act. So it was also the politicians as well that you were trying to get on your side. I mean, what year was that, Adriana?
2013. And I know that the ones that will be watching possibly this chat are young lawyers. I think this is something that I wanted to mention to them. I could never have imagined in my years of junior lawyer that I would end up by participating in the review of the law, to work. We had a mandate from the Congress to prepare a revised version of the law. So be prepared, work hard and be prepared, because things will happen, opportunities will arise. One thing quite interesting, I don't know even today why, from a political point of view, as our law was already a very good law, someone in Congress decided to reopen the discussion of the law. By the time we at CBAR, the Brazilian committee, said, wow, this is dangerous. Our first reaction was, we should take a lot of care, because we don't know the result of a discussion in Congress. A result can be very damaging towards arbitration. So we have prepared, by the time we had already a large group, it was 2013, large community. We prepared ourselves to, first of all, for specialists to be also appointed in this group of jurists. And also our first goals were, I remember quite well this, not change if it's not necessary. So we went through issue by issue of the arbitration law. Do we need to discuss arbitrability? No. Do we need to discuss provisional remedy? No. We have done some adequations, some adjustments to that. Do we need to discuss set-aside proceedings? No. Do we need to discuss the same article that reflects New York Convention? No. So we went through, we have a large, it was a 6-month process to discuss every detail of the law. First of all, to confirm that the vast majority of the law was totally okay, was totally fine. And we end up doing some interesting improvements. One of them, it's to put in the law what we call in a civil jurisdiction, it's a legal authorization for public entities, for all public entities to participate in arbitration. There was a dispute if arbitration law itself would suffice for a public entity to participate, and we put it in black and white. So from that moment on, a new area has emerged. You know, we have now dozens of cases involving public entities. So the law is there saying there were some other specific laws already allowing it, especially PPP projects, petroleum, oil and gas, and energy. But it's also in the general law now saying every public entity in Brazil is allowed to execute an arbitration agreement. And we have also had something in relation to the corporate law. We have made an adjustment also, because another interesting aspect of the development that we have noticed in Brazil is that because of the amount of work in judicial courts are so high, when we are dealing with corporate cases, internal corporate problems, assembly decisions, put option, call option, mergers and acquisitions, which is this one, general contracts, but you know, even voting rights, a vast majority of those cases are going to arbitration. So we had one issue to discuss, an interesting one, and I would say it out loud for the younger generation to pay attention to. We were discussing by that time if a company decided to change its method to solve disputes from courts to arbitration. If a decision on that was taken by the majority, would need to be taken by the unanimity of shareholders or by the majority. And by the very end, we decided that the majority decision was enough for the validity of the arbitration provision in the bylaws of the company.
And I mean, we'll move on from Brazil in a moment generally, but one thing, what do you think, given how much you've been involved in the changes in Brazil, what do you see the future? What would you like to see, one or two things in particular, change for the better in Brazilian arbitration in the next few years?
I think it's in every country, it's a delicate equilibrium. The community has to pay attention always because you know that even in UK, sometimes you can, all of a sudden, you may have a court decision that will be discussed in every arbitration congress for in the future years. So nowadays, we are seeing, as companies have realized that you cannot touch the merits. I think in the larger cases, in the billion-dollar cases, what we are seeing is an attempt to disqualify the arbitrator, as the window of opportunity to challenge the award is so narrow. And the judiciary is facing right now those issues, very complicated issues, which are which are the facts that you need to review. Do you need to review another arbitration with the same party, one on the case? So nowadays we are facing those subtle discussions. And obviously I would love very much in the future for the decisions to be quite mature. Another issue that we don't have yet in our arbitration law is a distinction of national public order and international public order. When we were discussing the law in 2013, I myself, I remember bringing this issue up. And we decided, we had a consensus saying, you know, it's not necessary. Everything that we try to change may create some discussion within Congress, as it's going quite well, even in relation to the analysis of international contracts. Let leave it this way. We had other, would say, more challenging issues to be faced with, which would be, by that time, labor arbitration and arbitration in consumer contracts. So, but I hope in the future we have had some decisions, Ben, very good decisions from the high courts also, making this differentiation from between international public order and national public order. So I would love for this to continue in a good sense. And what I would hope also is that our community is very young, vibrant. The older generation, like Luis Olavo Batista, they supported us when we were very young lawyers, quite naive in terms of the challenge that we would be facing. We want the generation that took part in that golden ages, I would say, we want that the young generation keep on being part of it, being part of the board of directors, being the engine for things to keep on going. This I think it's quite important, because I faced a lot of difficulties as a young lawyer, and it's common to have that. I've seen in Latin America, various countries in which I would see a senior lawyer saying, no, it's not your turn. It is also me who wants to be the president of this and that. And I think we should give space for the younger generations, for them to even to make errors, even to try to do new things, to do it again. They will make a lot of good take very good decisions. They will bring novelties that stable generations or older generation will not think about it. So, you know, we need to give space for a young generation.
I mean, that's a good, I suppose, time to move to your role, I suppose, beyond the borders of just Brazil, in some of those changes that you're talking about. for those of who are watching who weren't aware, in 2012 you were appointed to the ICCA governing board, and you were one of the first, if not the first, female South American arbitration practitioners to be appointed to the board. And your appointment marked the start of something of a revolution, I suppose, within the ICCA. And perhaps you can tell us a bit about the significance of your appointment, not only for you personally, but for the arbitration community as a whole, and both in Brazil, but I think also beyond the borders of Brazil, which
yes, definitely beyond the borders of Brazil. ICA is the leading academic institution worldwide since 60 years now. But ICA started with a group of friends in Europe, and it started to grow and go throughout the world to foster the development of arbitration. ICA did an incredible job for many, many years. By that time, Brazil, as we were a rising jurisdiction, we were very fortunate to host one of the ICA congresses in 2010, and I was the president of the Brazilian Arbitration Committee by then. So I've noticed that by the time, ICA was a small group of 45 senior, leading, especially European, male, gray hair lawyers and professors, an incredible group of people. But it was time, and I realized that because I remember once I had to go to a meeting in the capacity of president of CBAR to present to the ICA governing board the status of the organization of the Congress of 2010. I think this meeting was in 2008, 7 or 9. And I remember getting into the room and I saw the table of the 45 governing board members. And except for Gabriel Kaufmann-Kohler, and if I'm not wrong, Teresa Schank, the rest was only elderly, older, but extremely knowledgeable and people, but you know, there was no diversity back in those days. And what I've noticed is that the change came from within, from the top management in ICA itself. And I owe those efforts especially to Jan Paulson and Albert-Jan van den Berg. They have decided and they agreed within those group of 45, because their mandate would go until the age of 75 years old. So if someone started or was nominated to be a governing board member in the age of 50, would stay as governing board member for 25 years. So they made the revolution in ICA. They created mandates, 4-year mandates, can be renewed for another 4 years, but they changed it drastically. And I saw that. It was beautiful to see. I am a result of that, obviously. My appointment is a result of that, but it was not only me. And I think I was the first female in Latin America, but other young people, different jurisdictions, geographical diversity, lots of people from Africa, South America, Asia, not only in relation to that diversity in terms of job description, judges as well. It was already a mark within ICA to have judges, but you know, to think about it in diversity terms. Also the importance to have general counsel within ICA. So you have all the players from different regions. And also ICA decided there are many many other activities that we could mention within ICA that took place. But one of the major issues when ICA decides where to go in the next Congress is precisely regional diversity. So that's why ICA decided to go to Brazil in 2010. That's why ICA decided to go to Africa in 2016 and still keeps on choosing different places to foster arbitration in different regions. So I saw though that change within the board. It was beautiful to see. Beautiful to see. It was noticeable. You could see the table, new faces, young faces also, not only above 50 years old or 60 years old. It was very beautiful.
So your mandate at the ICA governing board will end next April. How would you like to see the board progress in the next 10 years?
The same way. I think ICA is doing an incredible job. I think ICA now it's an open institution. Everybody can be part of ICA. ICA has had different activities. One of the activities, it's a committee with the Tsinghua University in Beijing. ICA had a summit with HK45 in 2015. There will be a next Congress in Hong Kong. So ICA, for instance, participated, currently has issued different, has put together a group of experts to discuss cybersecurity, data protection. So I think ICA is totally renewed and is facing the challenges of today. I hope that in the future, obviously, those changes need to continue. But I think I'm very proud of the development that took place in ICA in those years, pushed by the effort of the old generation. The ones, they decide themselves to change.
I think you're too humble, really, Adriana, because I'm sure
not true.
You had a big role to play. Look, one of the things that I'm going to move away slightly from arbitration generally and back to you just for a bit for the last few moments of this call. And obviously last year you set up your own firm. So can you tell us a little bit about that? And what was it that made you make that decision? And what is it that you're hoping to achieve in the future in your relatively new role?
What happened, Ben, is it happened to a few lawyers. I started to receive appointments as arbitrator, and the appointments started to grow. So I was, when I was head of the arbitration team at Elo Baptista, we reached a group of 25 or up to 30 lawyers, if I'm not mistaken by the number. It was a large group of lawyers and a large amount of cases. And I felt that was, in a certain moment, I had to choose. Or I was going to start to not accept new appointments, or I would have to open my new firm. To avoid the conflicts of interest, because I was facing that challenge. Elo Baptista itself is a small size firm. It's a boutique in Brazil, 100 lawyers. Actually, for Brazilian standards, a medium-sized firm, but nothing compared to US firms. But even so, I was starting to create conflict issues for my partners, and they were starting to create conflict issues for me. So I decided that it was time. It was an interesting move. I love also to be a lawyer. I think it's extremely challenging to put a face in front of people, to try to argue a case, to try to convince someone else, to try to avoid the flaws of your case, the weak points of your case. You know, you could construe a narrative to improve the situation. And what I love about our career is the diversity issue, the diversity feature. I love to face in a case someone that has a different background. So we need to pay attention which background Ben has, because Ben, as a lawyer, will argue the case, or will decide cases as an arbitrator in this matter. But we would think differently. So I had a lot of fun for 25 years, but it is a burdensome job to do it properly. You know that you're from a common law jurisdiction, well regarded common law jurisdiction with top lawyers. So, and we were learning in Brazil to do that, you know. So every time we had every hearing, 1 week hearing, it's a lot of work, a large group of people. So after many years doing that, I decided that perhaps I would like to reserve my energy on the merits of the case, on deciding the merits of the case, which is another interesting aspect. You know, nowadays I still work in 2 cases as counsel, but not alone. I need to work with other firms because I don't have the proper size to deal alone with a case, and I have time to study, and I think this is precisely what arbitrators need to do. Have time to study the cases, have time to reflect on the case. We need to do, we don't, it's only one shot. We cannot make mistakes, or we can do as much as we can in order not to.
Yeah. So we're coming towards the end. I mean, we could carry on all morning, I think, but I've got to let you go at 10:30 at night in Brazil. But before we do, obviously we do naturally, given that we're hosting this here in Hong Kong, we have a lot of practitioners here from Asia, and because it's HK45, they're largely the younger practitioners. So perhaps we could leave with some comments from you on what advice, what sort of tips would you give to young practitioners in Asia right now, looking to develop their own practices and careers in international arbitration?
So it's a good point. I think first of all, the future is bright. I think we have seen in Asia, you are a product of that yourself, Ben. You have seen how much Asia is attracting foreigners to work in Hong Kong or Singapore or even China. It's very interesting to see that happening. Shows how important the market is, you know. So the market is good in Asia, and I think the 2 markets, especially Asia and Latin America, the market will keep on growing. I think I think perhaps the windows of opportunity, there are some interesting features there available for the younger generations. What will be actually, first of all, when we think about disputes, beforehand, we need to discuss or foresee, try to foresee a little bit trade itself. How the trade will develop in the future. Some economists say that as the trades from north to south has already developed too much, the new trend is south-south. And directly, especially, we know that China keep on having huge amount of trade with other players. So I think there's a window of opportunity for this younger generation to see those markets, Africa, African countries, Latin American countries, as markets that they could be specialized in, that they could know a little bit more about the culture. They will. I think I have had various cases with Asia already, various cases, and there keep on a lot of Asian investment in Brazil. So there will be cases. So the culture is very different. That you're a very good example of that. The way you are doing, I think it's quite interesting because you are living there. Another window of opportunity for this younger generation. I tell also to the Brazilian new lawyers that as Brazil is a huge economy, 10 years ago, it was worthless to have someone within an international firm that could speak Portuguese. Now it's not true. It's an asset.
Yeah.
If you have a Brazilian case, a large Brazilian case, you need someone that you can trust that can read Portuguese. It's the same for Asian countries. So there will be lots of opportunities within international firms and also to live abroad in New York, Europe, or even in other countries like Brazil. So I think there's a interesting market to develop. From a Brazilian point of view, for instance, we don't pay too much attention to that, but Africa is very important as well. We have various Portuguese-speaking countries in Africa. So Brazilian law firms for those countries could be interested in, or Brazilian arbitrators could be appointed in those cases. So I think for the young generation, there's a lot to learn. And what I would suggest also, Ben, as we don't have much time, but I would like to give that opinion, that advice, the piece of advice to the younger generation. Don't pay attention only to arbitration. Nowadays, what is crucial for me when I hire an assistant, it's not arbitration. I know that he or she will, because they are generally passionate about international arbitration, will learn everything they need to, but put a lot of effort on substantive law. Another major difference that I can see in the development of the career of lawyers is when they truly master a certain area of law. It can be arbitration also. I myself, I became known in Brazil because of arbitration. But is there space right now for that? Or is it better for you to move a little bit and to be more dedicated to, as you mentioned in your own career, construction arbitration? Is it better to go to be specialized in corporate arbitration? Perhaps yes. So, but definitely, I think a good lawyer is the one who can truly master civil law and commercial law, the principles of law. It's not arbitration. It's an incredible method, but it's just a method.
Yeah.
So it's all about the law. It's all about the merits.
Thank you. That's that. I mean, I endorse that entirely. Arbitration is a means for resolving disputes, but ultimately, I agree that it's the dispute that will, by and large, determine the outcome, and it's the substantive issues that always become the most important. I mean, it's been fascinating talking to you, Adriana. Thank you very much. I'm sure everybody has really enjoyed it as well. I mean, just a few takeaways from me, just listening to you. One of the first things is never stop learning. I mean, your love of learning, your ability to combine a career with continued education is fantastic and has obviously helped you enormously. And I think that's something that we all need to bear in mind, because it isn't very common in my peer group, at least. I think also always believe in yourself. That seems to be something that you have had, a belief and a conviction of where you wanted to go. And as you've said on a number of occasions on this call, I didn't expect this to happen when I started, but you were positive and you looked for those opportunities. And as you were ending there, look beyond your borders, look beyond what exists now, and think about where the gaps are. And I think that's fantastic advice for everyone on this call. So thank you just so much for attending, especially as it's so late there. We really do appreciate it. And for everybody,
it has been an honor.
For anybody who's been, I see that there's a few people who joined a little later. This talk is being recorded and will be available for your consumption later on, and you'll be sent a link to it. And please also do watch out for the next Fireside Chat. This is the first in the series, and it's been a fantastic start. There are many more fascinating talks to come, so please keep your eyes open. Keep checking our LinkedIn page, and you'll see the next event coming on soon. So thank you again, Adriana, and thank you to everybody who's attended. And everyone have a great day in Asia. Now we're starting. And Adriana, thank you again.
Thank you. It was a pleasure to me. Thank you very much. Bye-bye, Ben.
Thank you so much.
Send my regards to Krian.
Will do. Yes, of course. I know she'll be watching. Thank you. Thank you, Adriana. Thank you, everyone.